On behalf of my team in the Office of Technology Transfer, we want to welcome you to our 9th annual award ceremony. I see some faces in the audience that I think I've seen almost every year for 9 years, so thank you so much for your continued support. We understand that our faculty, our researchers, our clinicians have many demands on their time, but it's our privilege to collaborate with them in protecting, marketing, and licensing their inventions. The purpose of this ceremony is to acknowledge and honor the 2014 achievements of our faculty, inventors, including their technology, their companies, and their products. Thank you. Our IT guy is brand new, so he's still figuring out the system, but nice job. So 35 years ago, technology transfer was just a national experiment. As some of you may know, at that time, innovation coming out of federally funded research was owned by the federal government and ended up sitting on their shelves. So the country embarked upon a pretty novel approach outlined in the Bayh-Dole Act. This landmark legislation put ownership of these innovations in the hands of the university. And doing that allowed for universities and their faculty to align inventorship with local pride of ownership. And the results have been spectacular. In the aftermath of the Bayh-Dole legislation, universities like Emory began creating technology transfer offices. As a matter of fact, it was 30 years ago. Here at Emory, the technology transfer had a pretty simple beginning with no dedicated staff, but instead as an additional responsibility or role in the Office of Sponsored Programs. Today we have more than 17 staff dedicated solely to technology transfer. We have dedicated staff for marketing, licensing, federal and license compliance, research-related agreements, finance, and startups. We also have an in-house patent group, a metric-based incentive plan, and we also have, as of about a year ago, a proof of concept fund. Over the past 30 years, Emory has received more than 3,000 new inventions, resulting in 39 products on the market. You can see some of them on this product pipeline. And we've received over $845 million in licensing revenue. So we hope you'll join us throughout the year. Even if you don't join us, we'll force feed you our media through our very aggressive social media group in the office. To celebrate 30 years of Emory innovation by highlighting groundbreaking research that has come through our office and how it has positively impacted lives. We'll also share stories and milestones from the office that were steps on our path to becoming the premier program that we are today. In case you were wondering, the results are in from the first comprehensive survey of Emory University's 72 startup companies. These are startup companies that licensed in Emory technology, not companies that just relied on Emory intellectual capital. We found that our startups are very successful in a number of different metrics, from attracting funding to getting products to market to creating jobs in Atlanta and elsewhere. As far as funding, Emory startups have received more than $85 million in non-dilutive funding, more than $1 billion in private investment capital, more than $314 million in public investment capital, and $13.5 billion from mergers and acquisitions. Also, they brought 30 products to market from 20 different companies and employed, as far as we can track, at least 1,200 workers at their peak employment. So I want to shift gears and introduce our keynote speaker for this afternoon. You would think that with 27,000 employees at Emory, that I wouldn't be surprised if I discover that we have somebody among our ranks who's an international expert and thought leader. But I was surprised to learn just a few months ago about the existence of our keynote speaker, not just because he was just down the street in the School of Law, but because he's a rock star in patent law. So how could I not know about that? So our keynote speaker, as you can see, is Timothy R. Holbrook. Tim is Associate Dean of Faculty. He's also Professor of Law at Emory University. But before I invite him up to speak, I want to share with you some of his very impressive accomplishments. So Professor Holbrook is one of the nation's leading patent law scholars. He's authored over 25 publications and has given over 100 presentations around the world on patent law. His work has explored the patentability of human genes, the extraterritorial reach of U.S. patent law, and the function of patent disclosures. Now, for some of you in the room, you'll actually know what that means. His work has been cited in briefs before the U.S. Supreme Court, the U.S. Court of Appeals for the Federal Circuit, and various district courts. The Federal Circuit and district courts have cited his work favorably, and he has authored and co-authored numerous briefs before the Supreme Court and the Federal Circuit. He's also an elected member of the American Law Institute. Professor Holbrook has also been an advocate for the rights of the lesbian, gay, bisexual, and transgender community. Professor Holbrook graduated summa cum laude and as valedictorian from North Carolina State University, earning a BS in chemical engineering with a life sciences concentration. He received his JD from Yale Law School, where he served as a lead editor and publications director of the Yale Journal on Regulation. After law school, he clerked for the Honorable Glenn L. Archer, Jr. of the U.S. Court of Appeals for the Federal Circuit. Following his clerkship, Professor Holbrook worked in Budapest, Hungary, with the Hungarian patent law firm of Danubia. Upon his return to the United States, he associated with the Washington, D.C. law firm of Wiley, Ryan, and Fielding, where his practice focused on patent and appellate litigation. Professor Holbrook has published widely on issues of patent law, international patent law, and the patenting of human genes. His work appears in a variety of journals and twice in Science magazine. He is a co-author of the 4th edition of Patent Litigation and Strategy with Judge Kimberly A. Moore of the U.S. Court of Appeals for the Federal Circuit and John Murphy of Woodcock Washburn. Before joining the Emory faculty, Professor Holbrook was a tenured professor at the Chicago-Kent College of Law. He served as the Edwin A. Hafey Jr. Assistant Professor of Law at Stanford Law School, and also taught as a visiting professor at the University of Denver, Sturm College of Law, and Washington University School of Law in St. Louis. He was a scholar in residence at the Center for Media and Communication Studies at the Central European University in Budapest, and served as a visiting professor in their legal studies department. While in Chicago, Professor Holbrook was a founder and the program chair for the Richard Lynn Inn of Court. Upon arriving in Atlanta, he helped found the Atlanta Intellectual Property Inn of Court and served as its first president. He also served as an expert or consultant in a variety of patent litigation cases, both in the United States and abroad. Professor Holbrook has worked to advance the rights of the lesbian, gay, bisexual, and transgender community. He has served in advisory positions to groups advocating for the rights of persons with HIV/AIDS and members of the lesbian, gay, bisexual, and transgender community in Washington, D.C., Chicago, and Atlanta. He was co-counsel to the National Football League players on a brief before the U.S. Supreme Court in Hollingsworth v. Perry, which ultimately restored marriage equality in California. Professor Holbrook.
Thank you. I always enjoy attending this event. I study the law surrounding innovation, and so it's always great to see the results of innovation, right? I have a chemical engineering background, so it's always fun to see actual science. Sometimes I get a little bit concerned that as a lawyer, I'm really just a transaction cost in the world, right? And so I'd like to see that there's some benefit to some of the things that I want to do and that I study. Now that said, one would think that in terms of innovation, that you would want stable law, that you would want technologists, scientists, and innovators to be able to understand what's happening in the law, to rely upon the law, and react accordingly. Unfortunately, the federal government doesn't seem to agree with that, in that over the last 5 years, there has been tremendous upheaval in our innovation policy, and particularly on the patent side, in all 3 branches of government. So a little bit of fair use here, right? That you've got the executive, you've got Congress, and you've got the courts, all engaged in effectively patent reform, some would say patent deformation, depending on your perspective. And so what I want to lay out for you tonight are some of the dramatic changes that have occurred or likely to occur in the coming months with respect to patent reform and change in patent law. But of course that begs the question, right, why is all of this change happening? You would think that you want stability to allow people to plan accordingly, but that has not been the case. One dynamic that's taken place is concerns with international harmonization. And so this, for the most part, I think most view as a good thing. As I'll elaborate in a little bit, we were the outlier in our patent system, awarding patents to the first to invent, where every other country in the world gave patents to the inventor who was the first to file. So we've shifted and we've moved in that direction, although, as I'd like to highlight, we actually haven't harmonized our law at all. So in some sense, we now have a large transition period with lots of uncertainty at cost to not achieve harmonization, right? But at least that's driven some of what, some of the patent reform we've seen. The other thing that has happened is the emergence and sort of the ascendance of the patent assertion entity, right? Now, they've always existed. This is not really a new phenomenon that you have business structures whose entire purpose is to seek licensing fees for their inventions, and I clearly distinguish universities and small inventors from this category, the non-practicing entity versus the patent assertion entity or patent troll. And so I think there's this debate, right? Are they just sort of a cute little thing that we're not worried about, or some horrific end of the patent system as we know it? I'm on the agnostic side on this, right? And I'll explain when I talk about some of the proposed legislation why I'm not in favor of it. And then finally, the Supreme Court, after about 20 years of silence, has suddenly reemerged in the patent space, to the chagrin of many. For the longest time, they didn't really take patent cases unless they involved something beyond patent law, you know, the right to your jury trial right, that kind of issue. And so we've got the Supreme Court re-engaging in a way that I would say on average has reduced the values of patents in the United States. And their hyperactivity, as I'll explain, is a little bit shocking given that we have a patent court, right? The U.S. Court of Appeals for the Federal Circuit, which was mentioned in my bio. I clerked there. It's the patent court. It hears all patent appeals from across the country. So if you've got this expert court setting national standards, why do you need the Supreme Court engaging? I'll unpack a little bit of that, but that has happened, that we've seen more Supreme Court activity in the last 10 years than we have in the previous 50. Right, so let's start unpacking what's been taking place. With respect to the executive branch, the president, it's kind of interesting that in the last two State of the Union addresses, innovation and patents are actually mentioned. And in the 2014 State of the Union address, he talks about the need for patent reform. And this year, he actually discusses the initiative on precision medicine, announcing the Precision Medicine Initiative, working through NIH and through the National Cancer Institute, right? So I think in terms of broader innovation policy, that's generally a good thing. The proposal is to give $130 million to NIH for developing voluntary national research cohort of 1 million or more volunteers to deal with these types of issues. So there's a lot of talk of funding, which, whether that bears fruit is a different question, but it's a nice change given that for the past, ever since the recession, it's been about contraction, not about expansion. But the big thing that has concerned the president and then the agency, the U.S. Patent and Trademark Office, has been the issue of patent assertion entities and the reason that they can operate, right? The theory of why patent assertion entities can flourish are twofold. One, patent quality is terrible. And so you get a patent and you have no idea if you infringe it or not. So someone's threatening to sue you. If you are risk averse, you're going to settle, particularly if you are faced with steep litigation costs. Patent litigation is expensive, which makes my students happy because they can get jobs. It makes the clients unhappy, right? And then when you realize that for a patent assertion entity, their litigation costs are zero. Their only asset is the patent. So when it comes to discovery, they say, here you go, done. And most of the attorneys take these cases on a contingency fee basis. So there's not even an upfront cost of the attorney. The attorneys don't get paid unless they win. So those cost asymmetries are what really drive the market for patent assertion entities. And so the Patent Office has taken some steps to try and combat these issues, particularly on the patent quality side. There's been steps to crowdsource the review of patent applications to allow other people to contribute information to the examiners. Examiners on average spend about 18 hours on an application. It's not a lot, considering how important these inventions are. So allowing others to contribute and feed into the system becomes important. They're actually trying to give more technical training to the examiners. Examiners are people with technical degrees, but oftentimes they're recent college graduates. At times they're actually going to law school at night to become patent attorneys. And so there's an attempt to do more training for the examiners. There are efforts to reach out to small inventors through pro bono and pro se assistance. They're trying to force applicants and licensees to be more transparent about who actually owns the patent. That's one thing that the patent assertion entities like to do, is play the shell game. So that here's somebody who's suing, but you don't really know who the person of interest is. The thought is if there's more transparency, it makes it easier to combat the patent troll phenomenon. One of the big areas of concern for patent quality has been functional claiming. So not claiming something in terms of structure, but claiming in terms of the way something operates. If you think about it, if your claim covers every possible way of performing a function, that is incredibly broad and incredibly ambiguous. And so there's been an effort to clamp down on this functional claiming. This is really rampant in the software space, where you're not claiming particular code structure, you're claiming just a way of doing something. And so they've been trying to clamp down on functional claiming. They're doing some outreach to downstream users. So what the patent assertion entities have started to do is not sue the manufacturers of products, but to sue the mom and pop shops. Right? So you have a Wi-Fi system in your coffee shop, we're suing you for infringement, which they can do, even though the deep pocket is the manufacturer. There's been efforts to reach out to those smaller mom and pop shops to try and give them some help in dealing with these assertions. They've been trying to do more education and to strengthen enforcement of patents through the International Trade Commission, which prevents importations of inventions coming into the United States that are viewed as infringing. So a lot of efforts administratively on the executive side of the government to try and improve these issues. And a lot of this has come from the White House itself. They've got, of course, wonderful political catchphrases for some of these things, right? So protecting Main Street from abuse. We got to worry about Main Street. And that's the attempts to make sure that those downstream users have a toolkit available to protect themselves when the patent assertion entity comes knocking at their door. So that's just the executive branch. That's a lot, particularly for the Patent Office to be going through all of these changes. That alone is quite a bit. And there's more at the Patent Office. I'm going to cover it on the legislative side of things because it was these procedures are created through legislation, but there's a lot going on. Now, with respect to the legislative branch, in 2011, Congress passed the American Invents Act, or as I like to call it, the America Invents Work for Patent Attorneys Act, because it is the most significant change in the patent system we've had since the 1952 Patent Act was adopted. It's the result of years of patent reform, about 6 or 7 years of sort of talking about these issues. What's interesting about the American Invents Act is that all of the issues that spurred discussion of patent reform are not actually in the act. That those all fell out of the legislation, the courts had addressed some of them, but nevertheless, we end up getting the American Invents Act. The big change, of course, was the shift from a first to invent system to a first inventor to file system. Again, it creates closer harmonization with our trading partners, but not really. Most of the foreign jurisdictions are very strict. You've really got to be the first to file. For us, we have this, well, if you publicly disclosed before somebody else did, then maybe you have a safe harbor. It's a rather complex statutory regime that is not like anything else in the world. So we don't actually have harmonization, but we now have a lot of uncertainty as to what these new provisions mean. And we're going to have 20 years of a dual system, because the patents that issued until March of 2013, and even some that were pending there as of that transition date, are controlled by the old patent system. And now we're getting the new patents coming out, which means so long as those old patents are being enforced, we have two patent systems that we have to operate under. That's complicated. That's a lot of cost, right? So again, I'm not a big woohoo AIA fan, but that's what we have. I lost that fight. We also have new procedures at the Patent and Trademark Office, which I think are generally good. We have inter partes review and post-grant review. The idea of these new proceedings are to create cheaper alternatives to litigation to be able to challenge some of these bad patents. Inter partes review is already taken off because those apply to any patent out there. Post-grant review, with one exception, only applies to patents under the new system, and we only have had maybe one or two of those issue yet. So we haven't seen the PGR take off, but interest in these areas have skyrocketed. The filings have been astronomical, more than expected. The courts have been clear that they're going to stay litigation as long as these proceedings are taking place. So I think this is actually a positive benefit to the patent system to have these new proceedings in place. That said, right, 2011, that's the most significant patent reform since we had since 1952, yet already we're talking about new patent reform legislation less than 4 years later. Why? Patent trolls, right? It's really captured the attention and the imagination of Congress. They want to do a considerable amount of shifting and micromanaging of the litigation process. The big thing that they want to do, and there's a lot in here, is to flip our litigation system. Our current system, you pay your own fees, right? There is no loser pays system like we have, like exists in the UK. Only in the patent context, and excluding pharmaceutical litigation under Hatch-Waxman, for those of you who know what that means, they want to shift it and say, look, the loser will pay unless you can prove that the case was reasonable. The idea is that since patent trolls have no cost, making them pay the attorney's fees if they lose levels the playing field, and it hopefully reduces their incentive to sue. That said, lawyers should be really happy with this provision because now fees become an issue in every single case, right? At present, you only go after attorney fees and you can only get them if the case is exceptional. And I'll unpack a little bit what that means. But that means the vast majority of cases you don't fee shift. Now, if you're fighting over whether the case was reasonable, every case is arguably reasonable, which means you're going to have collateral litigation in every case about whether or not to shift fees, which is now going to cost more fees to do so, right? So again, attorneys should be like, yay, that's more opportunity for us. I think it's a bad move for the patent system, particularly when we see what the Supreme Court has recently done. There's also some micromanaging of, there's also some protection for downstream users. As I mentioned, the mom and pop shops, that I'm kind of agnostic on. I don't think it's necessary. If you dig into deep into patent doctrine, there are actually some rules about holding off the litigation against downstream users and going after the manufacturers. But the big one is some very strict limits on when can you do discovery in patent cases. I won't get into the gross, horrible details because I want you to all have a nice evening. But the basic idea is that if you have to interpret the patent in what's called a Markman hearing, right? If you're going to have this fight over what the patent means, you stop all discovery on anything else until you have that hearing. I don't think that's a horrible idea, but I do think it is bizarre that Congress is managing the litigation process. And if you think that Congress is really good at micromanaging things, then you have a more optimistic view of our legislative process than I happen to share. So that's the legislative side of things. But that's not enough, right? We've got the Supreme Court becoming incredibly engaged with patent law. So since the 2000 term of the Supreme Court, they've taken 33 patent cases. In contrast, they've only taken 11 trademark cases and 9 copyright cases. So this isn't a story about intellectual property. This isn't a story about innovation in some sense, right? Because copyright and trademarks have implications for the ways we bring things to market. And it's really bizarre because in the patent area, we have the expert court. In contrast, trademark and copyright go through the general appellate court systems, and there's a lot of times those courts disagree, which is sort of the classic time the Supreme Court takes a case. If you've got lower courts fighting over an issue, the Supreme Court intervenes. We don't have that in patent law. We do have it in copyright and trademark. Yet they're not taking the copyright and trademark cases, they're taking the patent cases. So what's at stake that going on, right? So this, for those of you who aren't aware, is the Federal Circuit. The White House is there, the Federal Circuit is there, there's the building. My office used to be there. It was the best office I was ever gonna have, right? Views of the White House, views of the Washington Monument. I love Emory, but I miss that office. So why are they so confused? And this sort of shows the distribution of cases they take in, the blue being the patent cases, right? That's a lot of cases to take in any area. But why are they so interested, given that they're sort of a generalist court? I think they're concerned about the Federal Circuit. I think that they really believe the Federal Circuit has taken our patent system into too favorable towards patent owners. I don't actually agree with that assessment. I think the Federal Circuit has different dynamics at play. But they really think that patents have simply gone towards overprotection. And so what you can see in a lot of these cases are outcomes that have really made obtaining patent protection far more difficult, enforcing patents far more difficult. You've got these series of cases dealing with what type of subject matter even qualifies for patent protection at all. Now, mind you, this subject is Section 101 of the Patent Act. They haven't really touched it in about 20 years or so, even 30 years. They take 4 cases in about 6 years, right? So it's bizarre that suddenly they go crazy over eligible subject matter. And so Bilski dealt with, could you really patent a business method? We are 1 vote away from having all business methods excluded from patent protection categorically. Everyone believes that Justice Stevens, who ends up concurring, was supposed to write the majority, and Justice Kennedy flipped his vote and ends up writing the decision. What that then unpacks are these other cases. Prometheus, which is of a particular importance to those interested in personalized medicine. It dealt with a way of optimizing the amount of drug that you gave someone. If you would measure the level of metabolite in the body. If it was too high, then you would alter it. If it was too low, you would bump it up. They said that's just a law of nature. No patent protection. If you think about a lot of the ways that genetic inventions operate, they're all about correlations and probabilities. Under Prometheus, those are laws of nature not eligible for patent protection. They all go down. You've got Myriad, the very famous or infamous, depending on your viewpoint, case dealing with the patentability of human genes as they are isolated from the human body. In a very unsatisfying decision, if you were a legal scholar, they sort of split the baby on that one. Say, well, isolated DNA is not patent eligible, but cDNA is. And every scientist I've ever talked to, when they read it, says that distinction is so artificial and has no bearing in the real world, but that's what they did. And then most recently, Alice, this past June, saying that in essence, this software is effectively not patent eligible. I think they've said there's probably hundreds of thousands of patents that now go away. Those who don't like the patent assertion entities, this is actually maybe a good thing because patent trolls tend to operate in the software space. Correlating with that is that litigation filings have dropped 30% since Alice was decided, the belief being that the trolls just aren't filing because their patents are now going away. In KSR versus Teleflex International, we know that to get an invention, it has to be non-obvious. The Supreme Court makes it more difficult to demonstrate that your invention is non-obvious in KSR. Now, if something is obvious to try, you cannot get patent protection for it. So that, again, ratcheting up the standard of patentability. The eBay case makes it more difficult. Sorry, I talked too much, so I gave myself my own timer, so I'm gonna wrap it up. I'm a professor. We can go on and on and on. So in eBay, they say, look, you don't automatically get a permanent injunction if you get infringement. you may get ongoing royalties, but you don't automatically get the injunction. In the case, there's this discussion of patent assertion entities because the risk of injunction gives you a lot of negotiating leverage if you're trying to get a fee. My firm was involved in the BlackBerry case back in the day. As you may recall, that settled for $600 million. I had left the firm. It was a contingency fee basis. I could be retired. I love teaching. But ultimately, that dynamic changes because now BlackBerry, when people cared about BlackBerry, wouldn't get shut down necessarily when they get the patent infringement judgment. And then this past term, there was a lot of cases dealing with the idea of patent trolls. Alice, as I mentioned, wiping out a lot of these patents. In the case Octane, I was talking about fee shifting, that the legislation is proposing automatic fee shifting. What Octane did is said, well, you can fee shift in an exceptional case, that's our language, but they made it far easier to show that a case is exceptional. So the hope is that district courts will begin to fee shift in these patent troll cases, hopefully creating an incentive against patent assertion entities bringing these cases, because if you're on the hook for somebody else's attorney fees, you'll think twice before you file the lawsuit. Nautilus dealt with the indefiniteness, how clear are the patents, and it's quite clear that the Supreme Court is trying to make patent terms clearer so that when you're charged with infringement by someone, it is easier to assess whether you infringe or not. And again, as I mentioned, eBay also deals with patent trolls. There's a Limelight case which deals with patented methods on the internet. I won't unpack that too much. But the Supreme Court clearly had an interest in patent trolls and those dynamics in the current term. There's also presently 2 cases pending at the Supreme Court dealing with patent law and 1 that was decided. So even this term we've had 3 patent cases. It is unprecedented, the level of interest. So what does this mean for everyone in this room? It means really get to know your patent attorneys well, right? It is shocking at the level of disruption that we are encountering in our innovation system, particularly with respect to the patent system. There's a lot to sort of wait to see how it settles out. And that's part of my concern with Congress's rush to pass this new legislation, is that we've had all of these Supreme Court decisions. The lower courts have to figure out what it means, yet Congress is rushing ahead with some proposed legislation which I think could actually be detrimental to the patent system. So with that, I will conclude. It is an interesting, exciting time to be a patent scholar, but it is a challenging time for those of you in the labs and doing the innovation and trying to bring these inventions to market. So I commend you for the work that you're doing. Again, it's exciting to be here to celebrate the successes that we've had at Emory, and thank you for allowing me to speak with you this evening.